So a new case is up for Supreme Court consideration, and this case deals with whether or not the federal law, which prohibits felons from being in possession of ammunition, is in fact constitutional or not. So let's talk about this. But real quick before we jump into this video, I want to thank the sponsor of this channel, which is Kershaw Knives. Kershaw produces amazing knives. They're durable, aesthetically pleasing, and I carry one every single day for my EDC. And right now, Kershaw dropped their new 2023 line, which includes a US-made automatic knife. So again, I love Kershaw Knives. A lot of people rely on Kershaw Knives for their EDC. And right now, if you go to their website and you order one of their knives using the code 20Scholar, you can get 20% off of your order and free shipping on orders of $100 or more. As I mentioned in the intro, in this video, we're going to be discussing a new case that is currently seeking Supreme Court review. This case involves whether the federal prohibition on felons being in possession of ammunition is in fact valid under the Commerce Clause. The plaintiff in this case is challenging whether Congress may criminalize intrastate possession of ammunition solely because it crossed state lines at some point before it came into possession of that prohibited person. This is an important case, not just because it impacts the federal law which prohibits felons from being in possession of ammunition. It could also impact, of course, their ability to be in possession of firearms, but also it could help unravel other federal laws and other federal prohibitions which kind of use the Commerce Clause as their underpinning. Now, the facts surrounding this case are absolutely absurd, and it's very interesting how this whole issue arose. Mr. Seekins was arrested on suspicion of stealing a U-Haul truck on June 17th of 2019 in Texas. Mr. Seekins was homeless at the time of his arrest, and he survived essentially by collecting things out of a trash can and then storing them in a U-Haul truck, which he used kind of as his home and which he slept in. When the police searched Mr. Seekins, they found multiple items, including a flashlight, cell phones, a lighter, a spyglass, and then ultimately they found one orange 12-gauge shotgun shell. When they asked where he got it from, where he got that shell from, he said that he found it in a trash can. The shell that Mr. Seekins had originally was identified by the police officers as a flare gun shell, which the officers initially did identify as that and wrote it down as a flare gun shell. Now, when they're searching the rest of the cluttered U-Haul, they found some other items like wrenches, other items like jumper cables, clothing for both men and females. And then ultimately what they found was a flare launcher that was in the cab of the U-Haul. Inside that flare launcher was also another shotgun shell. Later, the police found out that the flare launcher that was in the cab was in fact modified to potentially accept and shoot shotgun shells. Now, Mr. Seekins alleged that he found that flare launcher and those two shells in a dumpster. He wasn't aware that they were shotgun shells. He wasn't aware that the flare launcher was modified. He just simply thought it was a flare launcher. But ultimately, he was arrested and he was charged of being a felon in possession originally of a firearm. Because he had prior felony convictions, Mr. Seekins was initially charged with possession of a firearm under 18 U.S.C. section 922G. However, in the original lawsuit, Mr. Seekins and his defense gave notice of a proposed expert and a proposed expert testimony, which would show that the modified flare launcher did not meet the federal definition under the NFA and GCA as a claimed firearm. In response to that, the government then abandoned that initial charge of being a felon in possession of a firearm, and instead they completely changed the charge. And they charged him with one count of being a felon in possession of ammunition because of those two shotgun shells. Now, the record in the case contains no evidence that there was a commercial transaction of any kind involving these two shells, nor is there any evidence that Mr. Seekins essentially did anything, that he went and purchased them, if he went across state lines to get them and obtain them and bring them into the state of Texas. The government essentially made no showing. They provided no proof that Mr. Seekins sold, bought, or planned to sell these pair of shotgun shells. And it essentially made no effort to show when, where, and how they ultimately would have crossed state lines to the point where this was a violation of the Commerce Clause. The only thing the government did and presented in the case was a witness that showed that the company that manufactured those shotgun shells most likely did so in the state of Illinois. And even so, there was still a very slim chance that these shells had been manufactured somewhere else and then brought into the state of Texas. However, as a result of this, Mr. Seekins was sentenced to 70 months of incarceration under 18 U.S.C. section 922G1 for being a felon in possession of ammunition, and he was in possession of 2 shotgun shells that again he found in a dumpster. Mr. Seekins argues in his petition that the application of section 922G1 against him on these absurd facts is in fact unconstitutional, and it's an unconstitutional extension of Congress's commerce powers. Originally, he sought a rehearing in the 5th Circuit, but the 5th Circuit ultimately denied a rehearing. There was a vote of 9-7. There were 7 judges in the 5th Circuit who wanted to rehear this case, but ultimately they were outvoted, and in a 9-7 vote, they denied that rehearing. And in response to that, he is now seeking Supreme Court review, and that's why this case is now up before the Supreme Court. Mr. Seekins is now petitioning the Supreme Court to review his case and review whether or not 922G1 as applied to him and his facts is in fact unconstitutional. Recently, the Supreme Court held that under the Commerce Clause, Congress can only regulate conduct that substantially affects interstate commerce or has another evident commercial nexus to interstate commerce. Here, in this case, it appears that Mr. Seekins is trying to springboard off of the 1995 landmark case, United States v. Lopez. In the Lopez case, Alfonso Lopez was arrested for carrying a concealed weapon into his high school. He was charged under the Gun-Free School Zone Act of 1990, a congressional law that banned people from bringing guns into a school zone. Mr. Lopez challenged his conviction, arguing that the law exceeded Congress's power under the Commerce Clause. Now, in a 5-4 decision, the Supreme Court agreed with Mr. Lopez and struck down that federal law. This was the first time that the court struck down a law based under Congress's commerce powers, and it was the first time they did that since 1937. The importance of that Lopez decision was that was the first time in a very long time that the Supreme Court pushed back against Congress and their use of the Commerce Clause. In this case, Mr. Seekins is trying to use that same rationale to push back against the Commerce Clause and the use of that clause and how it was used against him because he simply had possession of 2 shotgun shells that may or may not have crossed state lines at some point. So this is a really interesting challenge that will impact some Second Amendment cases and our Second Amendment rights without actually bringing a pure Second Amendment case. This lawsuit is important because we have seen other recent lawsuits pop up with very similar allegations. Think of the Texas suppressor lawsuit and the bill that was passed in the state of Texas in regards to made in Texas suppressors. One of the claims in that lawsuit that the ATF is bringing, or that Texas has brought against the ATF, is the fact that the ATF under the NFA does not have the authority to regulate made in Texas suppressors because those made in Texas suppressors do not impact or implicate interstate commerce. Therefore, the argument is that the ATF does not have authority under the NFA and the claimed Commerce Clause powers of the NFA to regulate those types of items. A case here like Seekins can go a very long way to unraveling the claimed commerce powers of the NFA and GCA. And there could also be some other huge implications, not just for felons in possession of ammunition, but also potentially felons in possession of firearms and other items as well. And it could just really impact a lot of these other cases, for example, like the Texas suppressor lawsuit. So in my opinion, this is one of those very interesting sleeper cases that may not purely argue Second Amendment grounds, but it does have huge implications for the Second Amendment and the context of what executive agencies like the ATF potentially could do going forward, and whether or not Congress actually had the authority to regulate these types of items. Now it's up to the Supreme Court whether or not they want to hear this type of issue, but it is up before them, and it's a really interesting case with some really strange facts. But if we get any more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.